In 5 seconds. 4, 3, 2, 1. Blog Talk Radio.
All right. The I'm looking for Fourth Amendment jurisprudence. Good afternoon, everybody. How's everybody doing? Hope everybody's doing good. I'm looking for that Fourth Amendment document. This might be it. No, this one ain't it, but I'll keep it up here. I'll keep this one up. Let's get back to the chat. Good afternoon, everybody. Good afternoon, good afternoon, good afternoon. Well, good evening, should I say. What's good, Mr. Holbert? How you doing? Good, man. I'm good. I hope everybody is enjoying their weekend. Before I begin, I need to know if can y'all hear me, because I don't have my other microphone hooked up. So I want to know if y'all can hear me, and if you can hear me on a scale of 1 to 10, how good can you hear me? Let me go back to the call in. All right, y'all can call in. I think the number is in the chat. Yeah, it's right there. I'm gonna put the number in the chat again. See if I can do it. Oh, it's not gonna let me do it. All right, good, good. All right, so it's been a while since I've been on here, y'all. I'm sorry, but I've just been working on cases. I finished an appellate. It's a reply actually. It's a federal appellate reply brief that I finished, I think earlier this week, and we filed it a couple days ago. Something. What else did we do? We were waiting on a response from some defendants in another federal lawsuit. We got their response. So how that goes is we filed a excuse me, we filed a complaint to sue them in federal court. They filed a motion to dismiss. We filed objections and a response to their motion to dismiss, and they filed their reply to our response and our objections. And so right now everything is just pending before the district court right now for disposition. I really don't know how the district court is going to rule in the case, but I'm not an attorney. They hate us. They don't really like people who are not attorneys, and generally speaking, they don't really like to rule against their own colleagues. All right, because you're not supposed to know this stuff. I don't know how many times I got to tell people this stuff, but you're not supposed to know this stuff. But you can win. I'm of the opinion that if you get in front of the right so-called judge and you follow all of the rules and you argue your case pretty good, if you know what you're doing, I think you can win, because I've done it, you know. Y'all do me a favor, hit that like button for me if y'all don't mind. Really appreciate it. The second case, well, the other case is it's pending also. So we filed an appeal. We filed our appellate brief, and they filed their their response brief, and then we filed a reply. And so right now everything is just pending before the U.S. Court of Appeals. So it's kind of the same thing in in two different courts. That's what's going on right now. Tonight, I'm strictly going to be talking about civil cases and criminal cases. So if you have questions, You want me to look at some documents, whatever, tonight is the time. I'll be here for probably about 2 hours. And to be honest with you, I really don't feel like doing it, but it has to be done because I like to just support people who support me. Let me check the lines. If you want to talk to me, just press 1, and I'll turn the microphone on, and then we can start talking. Let me make sure I got this volume up all the way. Yeah, it's up. We can talk about anything. You can give me if you have something you want me to look at, just redact your own private information or whatever, because I'm gonna share it publicly unless you don't want me to. We can talk about if you want to try to sue somebody, we can talk about that. If you want to talk about motions, you want to talk about writs, you want to talk about appeals, um, you want to talk about child support, whatever. All right, whatever. Doesn't matter. Whatever. Let me check this thing again. All right. Give me a second, y'all. Let me get me a drink of water. I'll be right back, y'all. All right. Sorry about that, y'all. I'm back. Where's my water? Damn it. I left my water. All right. Got it. All right. So I got to let me check the lines again. All right, y'all. I got a caller. So let's go. All right, caller 0123. Good evening. How you doing? Let's make sure it's loud. Hello? Probably can't hear me. Let me see. Um, Caller 0123. Can you hear me?
Hello.
Yes. Good evening. How you doing?
Hey, what's up, man? How you doing, man?
I'm good. Can you hear me? On a scale of 1 to 10, how good can you hear me?
It's probably like a 8 right now.
All right. Can you well, you sound a little low. So
Okay.
I'm not sure what it is. Do you have me on speakerphone or something?
Yeah. It was on speaker. It probably was the headphones too.
Okay.
I
Your
had took
voice
them out
sounds
though.
familiar.
Yeah, I had called it before. I had called it before.
Okay. What's good,
But
man?
yeah, that's why I was calling back in for it because last time I was talking to you, I was letting you know I had my custody case brought back in under a Rule 60 motion and everything. And
Okay. I remember.
well, right before the custody case, they locked me up for an old speeding ticket, and they tried to give me like 180 days in court because I was asking for counsel and everything. They went through a whole trial without counsel. They never gave me counsel or discovery. Then they put me through a whole trial process, and I was back there. They had me in there. I was supposed to be in there for 180 days, but I ended up getting out early. And when I was getting out, they was like that I bonded out, but I didn't sign no bond papers or nothing. They just ended up letting me go. And then when I called the appeal lady, she said I didn't have to go to court or nothing. So I'm just wondering, like, is it over with or what?
All right. How long ago was this?
This was like a month ago, and it's like they third time doing it. Before I get, because this custody case been going on for 3 years. This speeding ticket been going on for 3 years. They've been dragging it back and forth. I come to court. There was times I come to court, the prosecutor wouldn't even be there. Then they're just, oh, you got to come back again. I'm asking them to dismiss it. They keep going back, like just keep having me come to court. And then finally, when I get the case, my custody case brought back in, they arrested me, which they were trying to give me 180 days in there, and it just seemed like a conspiracy or something. They working together. Every time I get I get a move in the custody case, they come and arrest me for a whole speeding ticket or something.
Let me okay. So these are two separate cases, correct?
Yeah, but
Okay. So
they happened around the same time.
okay.
First, first I filed for custody. Then the child support came, and they were trying to take that. But they told me, that's why I got the lady report. She was like, "It's nothing we could do because you filed for custody first, and it's nothing we could do because we need to see what's the custody going to be so we could determine the child support or whatever." So I'm like, all right, I'm just focusing on custody. And then one day she called like at night, and I listened to the voicemail. She was like, "Well, we got court tomorrow, and we're going to actually take the max out against you." And yeah, ever since then, I missed the court date because I was working night shift, and ever since then, they've been taking the max from me. But I'm just saying, I've been exposing that, like, because if you read the federal rules that they use to take the money, if you read those rules and stuff, it says that they are supposed to help you enforce any order you got. And I had an equal custody order from back and forth to court. She wasn't showing up. She showed up, not showed up, cause like she was going on and off. So they gave me an equal custody order, but then nobody would enforce it when I had the equal custody order.
Okay, well you have to move the so-called court to enforce it through what they call it. They might call it something different where you are, but you have to move for contempt. That's the only way. I'm of the opinion that is the only way that they can enforce their so-called judgments or decrees is through contempt.
Okay.
But back to let's talk about the so-called criminal case, the traffic ticket case. So you say it's been, I'm guessing it's been pending for 3 years, correct? Like what you said.
Yeah, I've been like they'll text me and then be like, "Oh, this is the court date." I get there, then they say, "We're not ready for this case," and come back again, and they've been doing that for like 3 years. But what really happened? They started.
I'm sorry to cut you off. Where is this at? What state is
in
this?
North Carolina.
North Carolina. All right. I'm screen sharing right now because I want y'all to see some stuff. So what you should do, what I would do, is I would file a motion for speedy trial. That's what I would do. Or
okay. No, it's on appeal. It's on appeal now. That's what they said. I don't even know if it's on appeal because the appeal lady told me I didn't have to do nothing. She said, I didn't have to come to court. It was for the speeding, and then they like sentenced me to. They tried to give me 2 years probation and some active jail time, and I appealed it in open court, and the judge got mad at that because I appealed it, and it was a stay. It was an automatic stay pending appeal or something. So he getting mad that he's still trying to arrest me. They put me in handcuffs and everything. I'm like, but I already appealed this case in open court. They got me in handcuffs, and I'm like, well, I want to take this to a federal court. This ain't like something ain't right here. The judge said that was a threat, and that's when they gave me the 180 days of contempt of court.
You probably have. You said you're in North Carolina, so I'm not really sure what the rules, like what the criminal rules of civil procedure in North Carolina require. I can go and read them, and find out. But generally speaking, once you give them oral notice of appeal, you're putting them on notice that you're going to appeal the case. You haven't really appealed the case yet. You have to give them an actual notice of appeal. Like you have to serve them a notice of appeal, like a document, notice of appeal. That's what you have to do. Generally speaking, they might require you to do something different there. Where the heck?
Okay.
That's right there. But let me see. I'm gonna screen share with you right now. See if I can find something for you. And a notice of appeal is all of this stuff is really easy, man. It is all of this stuff is extremely easy to do. I know it probably doesn't seem like it, but it really is because it's all the same stuff. You just have to find whichever rule it is, or you don't even have to bring the notice of appeal under a rule. You can just type in notice of appeal. You can put in the case name, your name, the parties, whichever court it's in, and you say I appeal the judgment entered on such and such date, and then you sign the piece of paper, and that's it. It's sufficient like that. That's a notice.
So you think it'd be better?
Huh?
It'd be better if I went. You think it'd be better if I went through, if I did it? Because they gave me the appellate defenders, but I feel like I feel like
You
they
need to
was just working with the state.
it's not bad if you it's not bad if you do have a public defender over your appeal unless they just lazy and they not gonna do anything. And generally speaking, that's pretty much a lot of them because they don't get
That's
paid for it. You know what I'm
yeah,
saying? So it's better
yeah,
if they gonna be lazy. It's better for you to just do it yourself. Nobody knows the facts of your case better than you. Nobody. Because you don't even have to go and look at you
yeah,
don't even have to read and go and see what happened because you like if it's something that was so tragic to you, you don't need a piece of paper to know that. You're just gonna
yeah,
record it off the top. You know what I'm saying? You don't need nothing for that. This me personally speaking,
yeah,
I don't really I hire attorneys for face card purposes. That's really it. I really don't care
yeah.
about their
Cause
paperwork because I can do all of my paperwork myself.
yeah, I use them for the paperwork too. But I feel like I know the process. I could read the law and stuff. They hide behind procedure more than anything. I know I could argue the law and stuff, and I feel like it's just when they see you without a lawyer, like you were saying, they don't never want to go against their own.
Yeah, but you got to make them though. You know what I'm saying? Do the bit. See, the best way to do that is if you got a court report in there, that's the best time to
Hmm.
do that. If you got a court report in there, because it's gonna be 9 times out of 10, it's gonna be recorded. Now they will. I'm not even gonna sit here and lie to you. They will lie under oath, and they will change stuff around on that court reporter transcript. I'm telling you what I know because I've seen it. They will do that. These people do not play fair. That's why I don't give these people any equity. If they lie to me, I'm gonna lie to them, and I'm not gonna
Yeah,
tell them I'm lying. They not gonna
yeah.
tell me they lying. I'm not gonna tell them I'm lying. I only give equity when
Mhm.
equity is due. I'm not giving nobody any equity who does not give me equity. I'm not doing that.
Yeah, so I was in there for like 30 days, and I was supposed to be in there when I got out because my girl was calling lawyers for me. It's like an investigation in the county where I was locked up at because it's like a lot of people they doing like a lot of fraudulent stuff. So the lawyer was telling me that he was like, yeah, this county is like really corrupt and like they're being investigated. But when I got out, he called me. He was like, "Man, I don't even know how you got out." He was like, "Because I'm looking at the paperwork. It still say you're supposed to be in there."
You need to go read stuff like I'm not sure if you're looking at the screen, but since you're in a so-called criminal so-called court, even though it's neither one of them, you need to read these rules of procedure. Let me see if I can, because sometimes they'll give you stuff like this for free, a sample. Let me see if you can't find it on here, then you can. Let me see. So hold on, give me a second. Forms and sample motions, arrest and seizure. Let's go back here. It seems like y'all looks like it's a little different. But this is what you need to go through this, right? What is this? Criminal Procedure Act, concurrent venue, waiver, notice, motion, allegations of venue, conclusive, attorney making general entry, obligated to represent defendant all subsequent stages, expunction of records. This looks like the stuff you need to be reading right here. So, for example, anytime you want to, anytime you want to file a motion, you either find a statute, you find a local rule, like one of your like the North Carolina civil rules. If they don't have civil rules, if it's in statute, like I said, you cite the statute, you cite a rule, you cite a case law, or you cite the Constitution. Those are the four ways that you bring the authority for what you're doing. And
And
then
I'm telling you, and
go
they
ahead.
like them judges is just like they just railroad and they like not even listening to it. I was coming with they wouldn't even give me an attorney because I kind of figured it out how to use because they would give me public defenders at first, and then I was arguing the Constitution, and they was basically telling me, "Oh, those are good arguments, but we can't use them." And yeah, we can't use the Constitution. Basically, that's what they were saying. And I'm like, "What the heck?"
Well,
And they withdraw,
go ahead.
but
Go ahead. I'm sorry.
yeah, I just figured out just looking up the statutes, the state constitution and stuff, and what to bring to them. And like the trial de novo, that's a big thing that they use in district court. They because it's not a court of record, so they basically violating the rights in district court and making you appeal to superior court.
Well, okay. Like, how long have you been studying? You sound, don't take this the wrong way, all right? But you
Mm-hmm.
sound a little new. You sound like you know what you're talking about just a little bit. So how long have you been studying?
I mean, I've been studying on and off, mostly for the child support is what I've been looking at.
Okay. But all of this stuff is pretty much the same thing. None of them are courts. They're not courts. They're administrative agencies. Every single one of them. They are all administrative agencies, and you're in a territorial court because you're in a so-called city. A city is a territory. Whichever city that you allegedly live in, they got a charter from the legislature, and the legislature authorized them a local government. That charter is the Constitution. It doesn't have to be called Constitution for it to be a Constitution, but that charter is the Constitution, and that charter authorized them a judiciary and a legislature and an executive. But the legislature can't give you any judicial authority because they don't have any. You're in a territory, man. Cities are administrative agencies. All right, that's really what you're dealing with. Administrative agencies are members of the executive branch of government. You're an administrative agency. You're an administrative court. They're deeming you a corporator, and they're exercising territorial jurisdiction over you through some form of minimum contact. Whether it be you have an address there, a driver's license, you pay taxes, or your kids go to school, or you injure somebody there who is a subject within that corporate territorial. That's what you're dealing with. All right, they're not gonna tell you this stuff. You can forget about that. They ain't gonna tell you this. But if you go and read the cases will clearly tell you that. If you read enough of them, that's what you're dealing with. But it's not hard. You can beat these people. But when they go to running over your rights and telling you you can't do this and you can't do that, you just all right, and you file your paperwork. You get your paperwork time stamped and everything. I had a guy, they did that to him. He contacted me. I think it was a child support issue or something like that. I'm not gonna really get into too much of the facts about it, but long story short, that's what they did to him. But he had contacted me to help him do some paperwork. So I drafted some objections for him, and what else did I draft? And an affidavit. But they still ran over him and did whatever they want to do. They didn't want to let him talk. But so he called me. I said, no, you need to go back down and you need to file your paperwork. These are just smoke and mirrors, man. Still file your paperwork. They got to answer that paperwork, man. They can say what they want to say. They got to answer that paperwork. But so what they'll do is they'll either expressly overrule your objections, and they'll tell you why, or they'll implicitly overrule them, meaning they're not gonna rule on them at all. They're gonna do what they want to do, and you just might as well just deem them that they overruled your objections. But they didn't. In his case, for what it seemed like to me, it seemed like that they implicitly sustained his objections because none of what they were trying to do was successful, and he got what he wanted. You know what I'm saying? You can't don't let these people do that, man. They public servants, they're executive administrators. All right. Y'all gotta keep these people in check. File your paperwork, make your objections, and study. Study, 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 study. I don't know how many times I gotta just study. Study. You're gonna make mistakes. That's okay. I still make mistakes. You're gonna lose. That's okay. Some of the best attorneys in the world lose. Some of the best so-called judges in the world lose on appeal. Don't worry about that stuff. Make sure you study and file your paperwork. Let me get me some water. Be right back.
Okay.
All right. Sorry about that. But back to the let's focus on this traffic ticket a little bit more. We'll give this about 10 more minutes and I gotta go on to the next caller. All right, so you say the traffic ticket or whatever. I'm guessing because you said it's appeal, so they adjudicated you guilty and somebody filed an appeal. Is that it?
Yeah, I appealed in open court. See, that's the thing. At first, they wasn't acknowledging the appeal. They arrested me for contempt, and then they were trying to say I only got arrested for contempt.
Okay.
But
So
that's not.
you are you in an appellate court? Are you in a court of appeals? Or are you in like a local higher court?
I don't. That's what I'm saying. I don't know. When I was in jail, I was calling the court of appeals from jail, and I'm asking them where my case was and everything, and they saying they don't got my case. They don't. They don't got nothing on me.
Let me see. Let me see if I can get you some answers, man. And that, trying to see. So you were in traffic court. You gave. I think you got to give them a written notice of appeal. Let's see what they say. We're gonna see what your what the case law says. Oral notice of appeal rules of criminal procedure. I'm of the opinion that you had to give them written notice, or I mean, you can give them oral notice too, but the written notice is what they really require. 2016 Rule 4 of the North Carolina Rules of Appellate Procedure provides that a defendant may appeal a judgment or order rendered in a criminal action by giving an oral notice of appeal at trial. Okay, well, they don't seem to say that they require a written notice. They just say oral notice. And this is from we got one case from 2016. Here's another one from 2022. Um, Rule 4 permits criminal defendant to provide oral notice of appeal. So that's sufficient. In North Carolina, that is sufficient. An oral notice of appeal. So you're right on that. All right. But you still have to do a brief. You know what I'm saying? You got to get a record. You got to designate what you're appealing. You got to do a brief. I'm not sure whatever else is required, but you have to go and read the North Carolina Rules of Appellate Procedure to know everything that is required when you appeal the case.
Okay, and then that Carl Miller video I was watching, the Constitution video,
Uh-huh.
or the Murdoch versus Pennsylvania case, and basically it was saying that when rights secured by the Constitution, it exists independently of the state's authority.
Yeah, they do because these are God-given rights. These are not civil rights. Civil rights are statutory rights. They government rights, or so to speak. They're really not rights, if you ask me. They privileges, but fundamental rights are God-given rights. You
Yeah,
have these rights as soon as you're born, but you have to exercise these rights, respectfully. You know what I'm saying? You got to be very careful with your rights. You got to do the right thing. It's hard doing the right thing all the time, but that's what you got to do. But did you have a question relating to that?
no, I just was going to try. Like I was thinking about using that in my custody case too. Like how just it's a God given right to have custody of my son, and basically it exists outside the
No,
state's authority.
you missing the point, man. Don't take this the wrong way. All right, don't take this the wrong way. All right, they cannot give you custody of your kid. You already have it.
Yeah, I know that. That's the fact that I'm saying. I'm saying what they did was wrong. Like, yeah, that's what I'm saying. I came in with equal custody. I filed for equal custody, basically because of what she was doing, violating my rights. That's what I'm saying. I came in with the rights. I left out without the rights. That's what I'm saying. That's my point of going back in the
My
courtroom.
apology. My apology. Um, do you have a copy of that child support ebook that I got?
Ebook, the first one. I didn't get the second one. The new. I remember you said it was a new one.
Yeah. Let me. I mean, it's pretty much the same thing. But well, in the author's opinion, he says the second one is better than the first one. All right. So if you can when you get some time, you can give me your email or you can shoot me an email and I'll send it to you. All right, so let me go back to Google because I want to try to see if I can get you some answers on your appeal. All right, so what's the name of the court that you appealed it from?
You said that I appealed it from Superior Court.
Okay, Superior. Well, it sounds like you should be in the Court of Appeals then. If you appealed it from Superior Court of North Carolina.
But when I called the
what county court was it, if you don't mind me asking?
Cabarrus.
Say that again.
Cabarrus County, Cabbarus.
Cabarrus. All right.
Yeah.
North Carolina. Okay, Cabarrus County Superior Court. All right, so you appealed it from this, so it should go to a Court of Appeals. It has to. Let me see. And this was a so-called criminal case. So let's go.
Yeah, they charged me with criminal speeding.
North Carolina Court of Appeals. Let's see. Majority of cases appeal from the superior and district courts, and civil and criminal cases are heard by the Court of Appeals. One major exception is capital murder. Blah, blah, blah. Superior, Supreme Court. I got that. If a member of the three-judge panel dissents from the decision of the majority, there is a right of appeal from the Court of Appeals to the Supreme Court of North Carolina. Trying to see, because some of them, they have district Court of Appeals. So I'm trying to see, do they have that there? They probably don't. E-filing documents, step opinions, calendar arguments, North Carolina Court of Appeals reports, search cases, summarizes, legal standard database, Court of Appeals mediation, history of the Court of Appeals building, appellate review court rules. And you called let me see what address this is. So this Court of Appeals is in Raleigh, North Carolina. Is this the Court of Appeals that you called?
Yeah, the Raleigh one.
All right. And you said they don't have a case for you. I tell you what, to find out if your case has really been appealed, you need to go down to the local court and get a copy of the docket.
Yeah, I wanted to go down there, but then I didn't want to go down there and stir up no more trouble.
You ain't going down there for trouble. You just going down there asking for your paperwork. And if they arrest you for that,
okay,
you need to sue them for that. That's what you need.
And they've been messing with me for a minute. Like, they call at the last minute, like, yeah, we need you down here. And then, like, I get down there a couple minutes, an hour late, arrest me for failure to appear, got a bond out, then come back to court again for the same case. That's how they just make money. They do little stuff like that.
Start costing them money. They gonna keep doing it. If you don't do nothing about it, they gonna keep doing that, man. You got to do something about it. You got to sue them. Start costing them money. Sue them. You can't get violent with them because it just ain't gonna end well. So just sue them.
Okay. And the Brady claim, because during the trial, I kept asking for the evidence. Where's the evidence? I've been asking the whole time. Where's the evidence? And they went through the whole trial without
file a motion for discovery. Once you file that, you got to make a record, man. You got to file your paperwork when you get your motion and you draft your motion.
Yeah.
And you go down to the courthouse and you file it into the courthouse. You make you numerous copies. Make you one for the so-called court, one for the prosecutor, and one for yourself. And get your copy time-stamped once you file everything else in. Get yours time-stamped.
Yeah, I got it.
That you can't.
I got a bunch of documents. Like, I never went in there without filing nothing, and that's what kind of saved me. Because all the the fake failure to appear they was charging me with, I got timestamp dates that I was there, saying like, yeah, this date I was there. That's what I was showing them in the trial. They just ignoring it because it's like a court thing. Like the whole court looking fraudulent now. Because the whole time I'm showing them, I was here that day. They saying I failed to appear.
So they
I was
must
here
wanted you to
there. I
make
was
a.
here.
It sounds like they wanted you to make a general appearance so they can start exercising jurisdiction over you. That's what it sounds like. I could be wrong, but that's what it sounds like. They can't force you to make a general appearance. If you want to make a special appearance, you can make a special appearance. I wouldn't even go to court. I would make a special appearance using paper. That's what I would. That's what I would do.
See, and then when they would see, yeah, I need to do that because they were every time I was saying stuff like that, they was just the judge was giving me warnings. Oh, that's a warning. We're gonna throw you in contempt. You can't be saying that. Like they just that's how they get you
Yeah,
now. They
they
just
can't.
throw
That's not
you
a
in contempt.
crime. They can't tell you what. You see what I'm saying?
I even called the sheriff on them for that. I'm like, even before I got arrested, I called the sheriff to make a report. I'm like, yeah, he's not letting me talk. If I'm speaking law, I'm coming out the Constitution. I got the Constitution with me. I'm showing him that this is coming from here, where it's coming from, and everything. This is all based in law, and he threatened me with contempt. I can't even talk. I made a report to the sheriff before I even went in the courtroom because I'm like, I felt like I'm like, yeah, this is funny right here. I already knew they were trying to do something funny.
You gotta make a record, man. Make your record. You gotta sue these people. You need to make an example out of them. That's what they're trying to do to you. You need to make an example out of them. You need to every time if they walk down the street and you get scared, you need to sue their ass. If you
Right.
hear a police siren and it scares you, you need to sue their ass.
Yeah.
That's what you need to. You got to cost them money, and you can sue them for stuff like this. I'm just letting you know. I'm not joking.
Yeah.
You might not be able to do it in North Carolina, but like in Alabama, you can sue for pretty much anything in Alabama. But you need to cost them money, and you need to know what your rights are. That's what you need to do. So anytime you
Yeah,
in
I'm
court,
telling you,
go ahead.
yeah. Now I've been filing like a lot of paperwork and stuff, and that's what I'm saying. That's why I was talking about both cases because they know me, and I've been exposing the child support out here. Like, cause yeah, man, it's a lot of stuff that went on, and I've been filing a lot of paperwork on them. That's why I got my case brought back in for fraud because her lawyer, like, he was just doing a lot of fraud and stuff. I think I got him disbarred. He's not even a lawyer no more. There's reviews on the page saying like, where is he at? What happened to him? Because he was just lying in my case, and I sent it to the bar. And I was basically letting them know that like they're liable. Y'all liable for him. If y'all the ones who licensed and
Hold on.
made him the attorney.
Somebody wants to talk to you. 717 number. Let me see. Give me a second. Let me see who that is. Oh, that's SG. All right, hold on, SG. Let me see if I can do it.
Hear me?
All right, SG. Can you hear me?
Well,
I can hear y'all, but can you hear me?
Yeah, I can hear you.
yeah.
All right. Hey, I'm at work, so I gotta, pay attention to what I'm doing. But I'm in a neighboring county from you, having some similar issues, and
Okay.
with I don't have a tag on my car, so I just have a small issue in your county dealing with that. But I've had an ongoing child support issue with Mecklenburg County, and I sent a complaint to the SEC. You mentioned the federal rules that they have. That those are guidelines. They don't have to follow the federal guidelines technically. So you mentioning that in district court, they're going to ignore you. You have to go by the statute, which is Chapter 110. Chapter 9.
That's what I'm saying. Those is based on the Social Security Act. Those guidelines came from the Social Security Act. They can't say they're administering Social Security under the Social Security Act if they're not following those same guidelines is in the Social Security Act. That's where it came from.
My point is they do have to follow those guidelines for them to get money from the federal government, the reimbursement that they get. But when it comes to the order that they're forcing on you, it goes by the statute. So you trying to have an argument in court for yourself, you can't go by the guideline. And they're going to try to. I mentioned it just because I know that they use the guidelines to securitize the order. That's why I brought it up in court, and they tried to overtalk me when I mentioned the federal guidelines, and that was fine because it didn't really have anything to do with me. That's between them and the federal government. It's between me or between you and the county who administers the child support order. It goes by the statute. So you have to cite the specific statute as far as you're concerned. It sounds like they put a default judgment on you. I assume.
No, yeah, I definitely got a default judgment, and that's why I put a Rule 60 to get it known back in the court. But
so did they actually have record of you being served?
They served the address, but they never served me.
So have you updated your current address with the traffic ticket and with the child support in the meantime, so they can't keep doing that?
I filed the paperwork to get back in court.
So the only other question I had was, did you file anything that would make them want to treat you like some kind of quote unquote sovereign citizen? Like challenging personal jurisdiction or anything like that?
Did I challenge personal jurisdiction? Or
did you try to do a special appearance? Anything of that sort?
Oh, yeah,
I'm wondering why they're giving you a runaround with a traffic ticket for 3 years.
Yeah, that's the same thing I was saying. When I went through the first district court, it was like a sham trial. I got in there. They like, this to do with speeding. The whole thing was I was never driving the car. That's what I'm saying. They charged me with speeding. I never was driving the car.
What?
That when he pulled
they
up,
got a license plate or something.
Man, what?
No, the car was parked in the back.
That's crazy.
Yeah, that's what I'm saying. The car was in the back. I never was driving.
So,
but he came. He was trying to.
Did somebody stop you and give you a traffic citation?
No, I came out the house. The car was moving, but I was never in the car with the people. I came out the house. I'm talking to the cop. Bam. He like, all right, it's just a speeding ticket. So I'm like, all right, just give me the ticket. But when I said that, he like, oh, is this a criminal charge? It's criminal speeding. We gotta take you downtown. And that's where everything just went. Cause I was like, the only reason why I said, all right, just give me the ticket. Cause he said it was a speeding ticket. I paid the ticket. It would have been done. It would have been nothing. But then they changed it into a criminal charge.
Man, you don't get that.
So you came out the house.
Man,
you came out the house. The car is parked.
Yeah, it was already parked.
You weren't in. So did the cop see the car in motion?
The cop was on the side. He was like in the front on the side of the house.
So nobody saw the car. Like I still need some peace.
No. I'm guessing he saw the car moving and everything, and then they pulled up, hopped out. Everybody hopped out. I'm talking to him. I'm like, I ain't about to be like, oh, who was driving and everything. And then he was like, it's just a speeding ticket. I'm like, all right, shit, just give me a ticket.
Did they have radar?
I said that, no, I was asking them for all that too. I'm like, all right, where's the radar? Where's the speed?
I don't know if it was the same. I don't know if it was the same issue in your county, but there was an issue in my county where they didn't certify the people that were supposed to be certified to calibrate the radar had lost their certification, so they were going back.
So same thing in my case. The officer that issued the ticket said that he was a rookie. He wasn't even trained to calibrate it. So they brought a whole new officer in and said this was the dude who gave me the radar. I never seen this officer before. I objected to this in trial and everything. They just ignored it. But I'm like, yeah.
It's already in the appellate court now. See, you all of this stuff could have
Well,
been avoided, man. You could have.
that was the other thing I wanted to. That was the other thing I wanted to mention is that there's a web page, I mean a YouTube page where it's a guy that reads out of American jurisprudence. The page is called The Tribe, but one of the things he read was on inferior courts, and it said in there that when you want to appeal a decision from a district court, it has to be appealed to superior court first, because the judge there is essentially oversees. It's kind of like the Supreme Court oversees the legislature. The superior court judge is actually qualified to review what happened in the district court. You have to have a transcript to appeal in that manner, and I think there's some other requirements that I could be mixing it up with another type of appeal.
No,
but there's
you're right.
one of those you have to have they expect you to have a contract with the people that create the transcript 2 weeks prior to the 30-day deadline to file an appeal. So basically within 2 weeks. So you should read the statute on that, the rules of civil or criminal procedure, whatever. It's in one of those statutes, and make sure you follow what their guidelines are.
Yeah, you're right. You're right. But that's what he has to do.
That's not even.
They've been getting me with procedural stuff, and I don't. I'm still learning about how to object and stuff like that. So with my custody, I filed contempt motions, and there was some funny business going on, and I think it's related to me catching them breaking the law with regard to the child support issue I'm having, and because the judge and the attorney showed up for the other party without notice, and the judge didn't even know they were coming. So once that attorney showed up the first time, all of a sudden the judge had to hurry up and get to a meeting. She was rushing to get the hearing over with. She never gave me a definite as dismissed or continued. It was just weird. So then I filed another contempt. The second one was a criminal contempt. A different attorney showed up, and they dismissed it, citing double jeopardy, where double jeopardy only applies to criminal. Like if you try somebody criminally and then you try to try them again criminally.
Yeah, you right.
But the first filing that I put in was a civil contempt, and I read case law on it, and you have to have made it to a point where evidence has been presented first of all. If we didn't put any evidence in. So all I'm saying is I'm pretty sure the judge and the attorney both knew about this, and they ruled that the judge ruled in his favor anyway to dismiss it, citing double jeopardy, even though I stated I didn't technically say I object, and maybe that was a problem, but I did say that it's like I don't know a whole lot about double jeopardy, but as far as I know, that applies to criminal cases, and the first case was civil, so this isn't making sense to me. But when in the end, I dropped that issue because it wasn't. All it was going to do was punish the other person. It wasn't going to fix anything else. So I just let it go. It wasn't worth my time. But
did you like bring up the right to enjoy the fruits of your labor and stuff like that? Like, because that's in the North Carolina Constitution.
Well, when you read the beginning of the state constitution, and you'll notice that where it talks about the people, the word people is not capitalized like people in the U.S. Constitution. So it's not talking about like capitalized citizens.
Yeah, they're not specific.
It's talking about it's likely talking about the people who created the quote unquote state of North Carolina, and that was created by the legislature and Congress. So you have to keep that in mind when you talk about who has rights and who doesn't. Now, in a district court, you're not there as one of the people. You're there as a lowercase citizen, which is a U.S. citizen, which is a 14th Amendment citizen. So you don't have rights in that court. You only have privileges, and you can't cite anything from the Bill of Rights because everything in there falls under the 14th Amendment. If you look at each of
that stuff, man.
Yeah, if you look at each of the rights, look at the rights under in the Bill of Rights, like the first, second, up to the Sixth Amendment or whatever. If you look up case law on those, find out which ones actually are applied under the 14th Amendment, because not all of them are under it. It's like they're almost optional, So they let you have just enough of them to make you think that you have rights.
Mm-hmm.
Technically, privileges as long as you identify as a U.S. citizen. As long as you go into a district court, you're not going to be treated like one of the people. So you have to keep that in mind. You go in there citing the Constitution, they will tell you that it doesn't apply and to not bring it up, and they might hit you with a contempt charge if you keep bringing it up, because it technically doesn't apply.
Yeah, you in a territory.
You're there under the 14th Amendment.
You in a territory.
Yep. You're under the 14th Amendment, so you have to go by the 14th Amendment in some cases, and you have to go by the state constitution and statutes in that court. Nothing else matters.
And they're not going. I'll be trying to tell people that they're hiding that stuff, man. They have to make it look they have to make it look real. They have to make it look legit, but it's not legit.
I think man. If you want to you possibly, to get that traffic thing out of the way. I don't know if you're familiar with that Don Quixote abatement in common law. You could possibly
I think
file abatement is A1. That procedure A1.
You could possibly file a Rule 60 motion for the traffic ticket and cite, use the abatement in common law what is that? What do they call it? Not law review. There's a section of it where it goes over the actual court decision. What do they call it?
What you talking about? A bill of particulars?
No. It's parts in there where they put example motions, but there's memorandum of law. That's what it is.
Okay.
It's like 20 pages long. You enter that as evidence into if you take that route. It's too late to put it into your appeal, because it has to be something that you brought up in the district court. But if this appeal doesn't work out, you could potentially, if you want to take it that far, you could do a Rule 60 and cite. Really, you could just say in writing that you rebut the presumption that you were using public roads as a place of business. It's those unstated presumptions that get you. And as long as you never rebut that particular presumption, they just nod their head to everything you say, and they find you guilty anyway. But if you put that in writing, actually rebut that specific presumption, that forces them to show proof that you were using the public road as a place of business. That's when they
go ahead, Izzy. I'm sorry.
That was all. I was just saying that's when they dismissed those particular issues. I had one more. I had a question about his child support order, but you can go ahead. I'll come back to that.
All right. So what SG was saying, like in regards to those presumptions, all so-called crimes have elements. All right, and those presumptions are part of the elements that you need to rebut. So, but they're just going off the presumption that they're true because you're not rebutting it. So they're going to assume that this element that they need to prove that you're guilty of this crime exists, or that it's already proved, or so to speak. That's essentially what he's talking about. That's what they're doing. He ain't lying either, because that's exactly what they're doing. They violating due process when they do that too, by the way, because you can't convict nobody without evidence. But that's essentially what they're doing.
Oh, okay, and that's what, just cutting off the compelling government interest. That way they can't have no standing in it. That's what you're saying, basically.
Wait, say that again.
If I ain't using cutting off the compelling government interest, because that's the only way they could get in, is they saying like that I'm doing some type of business on the road.
Yeah, okay, I get what you're saying. Yeah, because essentially that's what they're doing. They operating off the presumption that they have essentially a right to regulate your behavior, or so to speak,
Yeah.
if that's what you want to call it. But yeah, a compelling public interest. Yeah, that's what they're doing.
So is there any way to is this independently of the state, like just fucking off grid or something?
What do you mean? Hold on, what do you mean? I don't understand your question.
Cause I be watching like YouTube. I be seeing these people like build a private fence gate and just like go get some land like in the woods, and that they'll just build it up and then put a private property. It look legit, and then they've been doing it for some years. Then they own the land after a while or something like that.
Yeah, you can do that. You and the government on equal footing, man. The government, they can't. The reason why they give people an occupation tax. I mean, let me rephrase that. The reason why they give you a driver's license, they have to do that, because if they don't, then they can lose their right to enforce you having a license on you, because people will start. Let's say there's a private road, not a private road, but a public road that the city is not using at all. You know what I'm saying? So you start using the road. All right, but the road is so bad, it's in bad shape, it's just terrible. But you fix up the road and you start using it, and you start going from A to B, and you just start making money on the road or whatever. And the city knows about this, but they don't do anything to stop you from doing it. And then once you build the road up, it's looking real good, it's nice, you're making money. Now they come in and they want to ban you from using this road. They cannot do that. They are stopped from doing that. They slip on their rights. Lashes. You can't sleep on your rights. You on everything that they do over public property in the public, you can do over private property. But you got to get out of the city, because that's the democracy. And let me show you something. The reason why, in my opinion, you have to do that, this is the best way to do it. Let me show you something. Whatever you do, you have to do it in an equitable manner. It has to be in a manner that is consistent with the principles of equity. I think it's section 51. I think it was page 60. Let me see something. They're going over some principles in equity. I'm going to read you 2 of these principles. Must be 70. I'm almost there, y'all. Just bear with me. Must be 70. First, I'm going to read you this one. All right. This is in regards to, like, the city. After you fixed up this road, and they know you're on this road, and you just start making money, you fix up the road, it's looking nice. This is in regards to that. So I'm going to read you this one. Equity aids the vigilant and not those who sleep on their rights. This maxim is designed to promote diligence on part of the suitors being you or the city. Equity requires a party to assert his rights in a reasonable time after he discovers that he has been wrong. A person who delays suit not only by his negligence makes the proof of his own wrongs more difficult, but induces the other party to believe that he acquiesces in the situation. Besides, if courts allow suits to be delayed, a party may wait until an adverse witness dies or moves away before he brings suit. And this stuff is old. They was thinking about this stuff like 200-300 years ago. A party in the wrong may be so misled by the non-action of the party wronged as to do such acts and otherwise so change his situation that it would embarrass the court in granting relief. He who seeks equity must keep himself in a condition to do equity. And if, by his own delay, he is disabled from doing equity, he will be debarred, he will be stopped, he will be prohibited from receiving equity. It is bad faith. Bad faith is contrary to equity. It is bad faith for a party wronged to delay suit until the wrong cannot be righted without doing another wrong. Good conscience requires a party to do no act that will mislead another in his detriment, even though that other may have done him wrong. Hence, it has been said that nothing can call a court of chancery into activity but conscience, good faith, and reasonable diligence. In many in many cases, equitable relief depends upon the discretion of the chancellor. In equity, they don't call them judges; they call them chancellors. And the lashes of the complaint is often one of the most important of the elements taken into consideration when that discretion is exercised. This maxim is constantly applied where a party delays too long before he applies for an injunction or to be relieved against a fraud or seeks a specific performance of a contract or the rescission of a contract. It applies also to persons who do not inquire after being put on inquiry, to purchasers at public sales where there are no warranties or quality or title, and to those whose duty it is to take and to those whose duty it is to take necessary steps to perfect their rights by giving notice of the assignment to them of a non-negotiable chosen action, or by having their instruments duly registered. Equity delights in diligence and is slow to aid. And is slow to aid the slow. It it not only requires clean hands and a pure heart, but also swift feet. But if the defendant has caused the complainant to sleep, he cannot complain of it, for that would be to take advantage of his own wrong, and you can't do that in equity. The last one I want to read you is this. This is why you have to move out of the city, because one, you can't infringe on nobody else's rights. All of these people, there's a lot of people in the city that don't even know this stuff goes on, and they happy there. They don't mind paying the taxes because they get all of the benefits, and taxes are conditioned on benefits. So you just need to leave the city, just leave. But this is the reason why right here. It says, so use your own, so use your own as not to injure another. While this is a common law maxim, it is often applied in equity. The Chancery Court frequently enforces this maxim by enjoining the erection or commission of nuances to the complainant on the land of the defendant, because although a man may own the land, he has no right to so use it as to prevent his neighbors from enjoying their land. That's why you got to get out of the city. A man may be driven from his home by bad smells, noxious vapors, unbearable noises, shocking spectacles, and other intolerable nuances upon his neighbor's land quite as effectively as driven away by physical force. A man cannot so divert a stream on his own land as to turn water injuriously upon his neighbor's land, and he cannot dig so near the land of his neighbor as to cause the latter's land, meaning the neighbor's land, to cave in, or so near as to endanger his neighbor's wall. He cannot pollute a stream that flows through his neighbor's land, nor can he so stop or change the current of a stream as to prevent its ordinary flow through the land of another. A creditor, having his choice of two funds, ought to exercise his right of election. I'm sorry, what's that? Collection? No, that's election. In such a manner as not to injure other creditors, who can resort to only one of these funds. And it may be laid down as a general rule that no one can so exercise a right as to impair the right of another, especially if the latter is of equal dignity in the sight of the law. We all have the same equal rights. That's why you got to get out of the city. The rights of the life, liberty, and property and the pursuit of happiness must all be so used and exercised as not to impair or injure the equal enjoyment of these rights by another. The Chancery Court will, on due application, enjoin the defendant from so using his property or so exercising a right as to injure the property or rights of his complaint. Of the complaint. That's why you got to get out of the city. You can't do what you want to do in the city. Yeah, you're sovereign, but you're not sovereign in the city because that's the democracy. And it's majority rules out there. So it is what it is. They have every right if they choose to live under that democracy, just like you have every right, if you so choose, to leave. So when you leave, you're going to buy you 10, 20 acres or whatever. You do what the hell you want out there. You can turn it into a private city.
Yeah, I'm trying to do something like that.
Yeah.
I mean, not like that big,
But
just something,
like everything
private.
everything they do, you can do. If you want to build your own roads out there, you can. You want to put you some stop signs out there, name your own streets, put you some houses out there, make up your own house address. That's what y'all need to be doing. You need to get rid of these minimum contacts. That's what you need to do. You need to make your own ID, get your CPN number. All of this stuff is lawful for you to do. You're on equal footing. They can't sleep on their rights, and you can't sleep on yours. This is the stuff that they're hiding from you, and they don't want you to know. They don't want you to know this stuff. But I'm telling you, it's real. I've read the cases. The fact that this is a principle right here tells me that there are a lot of cases out here like this. A whole lot. So anytime you're doing something, you need to always act in a manner, I can't even get the words, in a manner that is consistent with the principles of equity. You can do whatever you want, so use your own as not to injure another. You got to get out of the city, fam. You got to get out of the city, because that's the only way. That is the only way. Ain't no telling how many people in that city, and they don't have a clue. None of this stuff go. They probably don't even know that they can do half of this stuff that I just told you that you can do. But I'm telling you, you can do it. That's why you need to grow your own. I would not go back to the city. Nobody should be living in the city unless you have a business. That's the only time you need to be down there, because everything down there is a business. The house you live in is owned by somebody who is doing real estate.
When exactly did the state start owning everything? Like, I know, like way back in the day.
Yeah, they don't own.
Now, I mean, like, yeah, I know they don't, but like, you know what I'm saying? Like, when did it start going to the state? I know back in the day, you could just like go out west. They was like and grab some land, a house, build your stuff up.
When they started forming these municipal corporations and applying for corporate charters, that's what they did. They did it everywhere. They did it everywhere. So this is what. Let me give you an idea. Now, I did a video on this, and I was reading the case, and I was showing people the case. But they got the people. I'm sorry, the people who were in the area who owned the land at the time, or whatever, because the legislature cannot do it without the consent of the people who own the land. That tells you right there that they don't make law. But anyway, so the legislature set stipulations, or so to speak, or conditions on granting these people corporate charters to perform municipal corporations. And if you met the qualifications, then they granted you a charter. They allowed you to have your own police force. They gave you a court. you know. They gave you a legislature, which is a city council, and they gave you a mayor and a police chief, and so on and so forth, like that. But it was over a geographical area. So from point A to point B, they had to designate where their corporate territorial jurisdiction was going to start and where their corporate territorial jurisdiction was going to end. And everything outside of that corporate territorial jurisdiction is not subject to statutes and ordinances. I'm telling you what I know. That's what they did. But if you're going to move out into a rural area, I'm probably about 99.99% sure that there is a that the county, because the county has a charter too, and they're municipal corporation. They might not be a municipal corporation, but they are some form of corporation. I'm of the opinion that it's a municipal corporation, though. That's my opinion. But anyway, because the county is an administrative agency too. But anyway, they're exercising territorial jurisdiction over that rural area. So if I were you, when I move out into any rural area, I'm sending us a cease and desist. I'm putting them on notice. Hey, look, I don't want any benefits from y'all. I just want to be left alone. I want y'all to stop exercising corporate territorial jurisdiction over this land. You know what I'm saying? I just bought it. Yada, 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 whatever. You know what I'm saying? If they don't act on it, oh well. They can't sleep on their rights and you can't either. You know what I'm saying?
So you saying when you buy some land, the best thing to do is like to file some paperwork and then see how they react to it.
I don't care if they react or not. Just make sure you do what you're supposed to do. He who seeks equity must do equity. You just make sure that you act in a manner that is consistent with equity. You're moving out here like, hey, look, I'm putting you on notice. Like, look, I'm new out here. This is my land. I don't know if y'all are exercising corporate territorial jurisdiction over this land, but if you are here, I want you to stop and I want you to cease and desist from exercising all corporate territorial jurisdiction over this land. But you're still under the law, though. You're just not under statute law. You're under God's law then. You're under equity and common law then. So you still can't do what you want to do. Unless, you know what I'm saying, you do it in a manner that is consistent with equity. You know what I'm saying? Don't kill nobody unless it's in self-defense. Stuff like that. You know what I'm saying?
Yeah. And this is my last question. Do you think a class action lawsuit will work for, like, because I talk to a lot of guys that are just going through missing their kids and child support, taking money and stuff like that. I just feel like if everybody came together and just said at once, like, this ain't right, we want to take care of our kids. I mean, I feel like a class action lawsuit would. I wonder what do you think that would do?
Yeah, to do something. Yeah, I need to get with this dude right here. This is the guy who wrote this. This is his website. The guy who wrote these ebooks on the child support. This man knows what he is doing. He know exactly what he is doing. He's got cases. They don't even want to rule on his stuff, man. And I'm not lying to you. This man know what he's doing. I haven't read his stuff thoroughly. I did a cursory review of it. And just that little short review, I'm like, okay, he sounds like he know what I think he know what he's doing. I'm of the opinion, in my opinion, that he knows what he's doing. That man is not lying. They hid this stuff, man. Let me show y'all something. Let me check these phone lines right quick. They hid this stuff from y'all, man. Not y'all, us. These are all the cases. Where's it at? That I found out there, obviously more. But these are all of the cases relating to some form of child support. The oldest one is from like 1802, I think. Where is it at? I think it's from 1802, something like that. These are extremely old cases, but they've been knew about this stuff, man. They've been knew about this stuff. But you need to go and follow this dude right here. Let me show you who I'm talking. Y'all need to find this dude right here. He got a Facebook page. Y'all need to find this dude because he's litigating right now in federal court. You can read all his stuff right here. I'm gonna put his number. I'm gonna put the link in the chat section. You can read all his stuff right here. If you think I'm lying, go and read this. This man know what he's doing, y'all, and he's doing just that right there. What you just asked me, man. That's what he's doing because He got it.
Yeah.
It happened to him with his kid's mother, if I'm not mistaken. My bad, SG. I'm sorry. I'm sorry. Let me see. How do I? I don't even know how to turn it. Let me see. What is this? Hang up. I don't know how to. I guess turn the microphone on. I don't know what I'm doing, SG.
It said I'm unmuted now.
All right.
Can you hear me?
Yeah, I can hear you.
Something else I forgot to point out is with he was talking about having a split custody agreement. When you hear you should talk about substance over form and form over substance. When you talk about like chancery courts, they go by form over substance. So if you have a contract, no matter what you actually are doing, they go by what the contract says. But
Yeah,
with
that's right.
child support and the district court, they go by substance over form.
All
So
of them
even
do.
if you have if you have a custody agreement, it doesn't matter. They go by who the child spends the most overnights with. They count. They go by. They have different tiers for what percentage of child support you pay based on the number of nights that your child is with you over the course of the year, whatever time period they go by. So you haven't had your opportunity to say, you know, my whoever was with me so and so amount of nights during that period, so I shouldn't be paying or anything like that. Now, then that brings in the question: was your child being kept from you? That's another issue. So
Yeah.
you mentioned something that the attorney said there was some kind of investigation going on. Was that for child support or something else?
No. When I filed my rules, I filed a bar complaint on the attorney because he never sent me the motions or nothing to reply to after the trial. And my custody case is so like there's so much stuff going on because I had equal custody the whole time. I didn't have to file until my son was like 10 and his mother went to Georgia. We had been separated since he was like 2 or 3, but it was like equal custody basically the whole time. And then she ran to Georgia, so that's when I went to file for emergency custody. There was never no child support until after I filed for custody. That's when like child support just came around after.
Okay, so you didn't, after she moved, you didn't really see him?
Yeah, but that's what I'm saying. They were charging me back pay when they first came out. They were like, I owed from like 3 years back. I don't know what they were. I don't know what. I think it was like 3 years or something. They were trying to say I owed from the whole time, basically, or something. I'm like, bro, I didn't owe.
Okay, so the child support was initiated by her in Georgia?
In North Carolina, while she was in Georgia. She didn't even come to the case. That's what I'm saying. She didn't initiate it, call the state. The state did that on their own after I filed for custody somehow. And that's what I'm saying, because the address that I used to file for custody is the address they used to serve me in the custody and in child support. I only written that address down on a piece of paper, the one I filed for custody for, and I was already moving from that address. Like I was already in the process of moving. I didn't want it to go on no more, so I had to file the custody paper. So I used that address. That's where they said they served the child support paper at. So for them to get that address, they would have to go. Yeah, they would have to go on my custody file and look at the address. That's what I'm saying. How did they even get that address? Because she was in Georgia, and then she didn't even go to the child support hearing.
The work record. They can get your employment information if you're working.
But I never used that address. That's what I'm saying. I never used that address. I only used the address when I filed on a piece of paper for custody. I'm like, all right, bam, I'm gonna use this address right here, bam. I put that address on the paper.
If you using
that's where they served it.
They gonna find you, man. I don't care what you using a social security.
I mean, they might have picked one they knew you weren't living at just so you couldn't fight them. I mean, they get what they want and they make it hard for you to undo it. They might have done all that on purpose.
Yeah, they probably did.
I
They
know,
can't prove that, but they probably did. They will do stuff
no,
like
I
that
know
too.
the,
They will do stuff like that.
yeah.
Man, let me show y'all something, man. Do y'all see this?
Oh, before you go, you're talking about basically about a allodial title. What they,
Yeah.
from what I understand, I think either you or Yusuf put up a video of a guy kind of like Carl Miller, but it was somebody else, and he went over a allodial title briefly. But I got a couple books from a guy that I forget his name, but he was in I forget whose video it was, but the guy mentioned him, and then I found his phone number and contact. But he wrote books about getting a allodial title, and where they get people is when you buy a house. One, the tax office sends you tax papers, and people don't rebut or respond in a way that lets them know that you disagree with the assessment they send you. Where they send it to a residence, and you know about that whole resident thing, where that is a corporation. That's not a living person or man.
It's in that
And
territory.
then they on the survey, they go by lot. They don't go by meets and bounds. So that's automatically going into the 14th Amendment system. In a corporation or a state, a country, no person or entity can own land because they're not real. So land is a real thing. So you have to be acting in the capacity of a man to own land. So as long as you're not acting like a man and you're acting like a person under the 14th Amendment, you can't own the land. You can live on it. And that's why they have real estate, because that's not the actual land. That's the house or the building on top of the land. And even though you have a deed to it, if you read it, it's worded in a way that lets you know you're leasing, you're a lessee, you're a renter. There's nothing in there that talks about ownership. And they get you by first. But that last video, they said that you have to have the survey redone, and it has to be redone in meets and bounds based on the Washington D.C. measurement or whatever. I don't remember exactly what they said, but it starts with the survey and acquiescing to the tax. So you have to get that stuff redone. So even if you live in a city, you technically that city is an overlay. Like when they talk about the Buck Act, where you have the United States of America, and then you have the United States, and people assume they're the same thing, but one is basically in our minds, and the other one is a real thing. And it's the same with a city or a county. If they all work under that state of or commonwealth of system, they're in our mind. So as long as you agree to use that system, then they make the presumption that you're a corporation, and they treat you like one until you properly rebut the presumption. And that's what I wish I could remember the guy's name that I got the books from. I didn't finish reading them. You know, I'm dealing with a lot at the same time, so I never got to finish reading it. But he gave the history of land ownership in this country, and it went from people having, it started with land patents, you know, after all the treaties and wars and whatever, all that stuff that happened, they had all this land, and since the government can't own land, it's only entrusted to the government until the people come and take ownership of it. So the government is the trustee of the land, so they take care of it, hold on to it until somebody comes to claim it. And nowadays, most people don't claim it; they just want to rent it, and even though they think they own it. But as long as if you're paying taxes on it, that lets you know that you're exercising a privilege, not a right. So, but you got to keep in mind, if you don't want to be paying taxes, then you have to do all that work that the government takes care of. So you got to pay the police. You got to get your own water. You got to take care of your own sewage. You got to take care of your own electricity and all that stuff on your own. So, you have to decide which one you want to do. But as long as you're, accepting their privileges, and you got to accept everything else that comes with it. And that's like what the Ashlanders. The Ashlanders will say you can't complain about the constitutionality of something if you're enjoying the privilege. So you got to pick. You can't be lukewarm like the Bible says. You got to be hot or cold.
Okay. Hey, when you first got on, you said something about challenging jurisdiction. Was that a bad thing?
Well, I was just wondering why they were going so hard with messing with you. Like with my particular issue is once I finally got in front of a judge and made it clear that a particular statute was violated and that my child support wasn't supposed to be taken from me without me having the right to appeal the decision, they continued the case. That was the end of last November, and they still haven't scheduled a date. But what the decision said was that the hearing needed to be in front of the judge that made the original ruling, and that's what the statute said I had a right to do in the beginning. So that let me know that they saw exactly what I was talking about, and they agreed with it, but they just didn't come out and say it. And they still haven't set an option to have a conference where you can come to an agreement, pay a certain amount. And we had that conference, and I didn't agree. I knew I didn't owe it in the first place, so I said no. But if I had agreed to pay a certain amount, then they would have put an order for that. And you can't appeal that decision because you agreed to do it. So they put the child support orders in as if everybody's agreeing to a certain amount, even when they didn't. So that by doing that, when you agree to pay a certain amount, you're barred from having a hearing to contest the child support order. And that was what they did to me, and they weren't supposed to. And it is apparently it's not just me. At the very least, it's everybody in the county. It's possibly everybody in the state. And that's why I was curious if you had your order, because I wanted you to take a look at the terms of it and see if it said that it said something like you waive the right to contest you waive your right to prior notice of income withholding, something like that, or you waive the right to contest the order. It's one little sentence that they slipped in there, and I was just wondering if they do it in your county also.
Okay. I don't think it's on the...
So read the order and see it.
Yeah, I read it. I got to reread it because I probably wasn't looking for that, but I read it, and I don't think I seen it. I got to reread it. But they do that because when after the lady called me after saying there was nothing they could do in my case because I filed for custody first, and then when I went down there the next day after the court hearing, she definitely put like a bunch of papers in my face and was like, "Oh, we probably could fix it if you sign this." She was like, "Just sign this. All you gotta do is just sign this." She was like dying to get me to sign that paper, and I ripped it up in front of her face. I'm like, "Bro, I'm not signing nothing. What do you mean? You told me it was nothing y'all could do. I would have came to court and fought this. If you say it was nothing y'all could do, then you call at the last minute like, oh, actually, we trying to take the max amount against you." That's like, I got this stuff recorded too. I'm like, how you gonna call at the last minute? Oh yeah, we want to take the max out against you.
I've only had to deal with your county in the last couple months, and I went to their courthouse. First of all, they got signs up in there saying that you can't go in there with a cell phone. And
that's the craziest shit in the world. But
it's like, the judge doesn't have the authority to outside of the courtroom. So I want to look. They said there's a statute that allows me.
No, it's a Judge McGee. He made the order, and I was asking him about that. I'm like, is this dude? How is he a judge and a legislator? How is he making laws that we can't bring a phone in? They don't want to be recorded.
I said something about that. I said something about it at the scanner. And the next time I went in there, they took those little paper signs down that they had, but it's still posted outside the door. It's like painted on the glass. But another thing I noticed is that I went in there to request body camera footage, and I had the form that I needed to turn in, but I went to the wrong window. And it seems like half the people you talk to in there, once they find, the lady asked if I was an attorney. I said no, and once I said that, it was like she didn't listen to anything I had to say. She was just always cutting me off. It was really working my nerves. They had me go up to the prosecutor's office when it was my fault because I needed to go to the civil filing window and I went to the criminal filing window because citation technically is civil. I was thinking about the citation and not the fact that it's a separate case to get body camera. So that was my fault, but I didn't like their attitude in there, at least at the criminal window. She went and got a supervisor. The supervisor didn't know what I was talking about. I'm like, it cites the statute right here on the form. If you want to look it up. I need you guys to date stamp this before I give it to the prosecutor and the sheriff's office. But
yeah, they're gonna give you a hard time. That's all they know how to do out there, man.
But it's easier in the county where I live because you can do stuff online. You can look up everything in the case and everything. But your county, still, you got to stuff by paper. And,
and then
y'all got a lot of sheriffs and cops riding around there, and I'm still riding around with no tag. But it was a cop right behind me. It was a cop right behind me when I left the courthouse, and on whatever that main street is. And once the second lane opened up, they just took off. But they hit the gas so hard the tires creaked. I think he was mad. I think that they probably got some kind of notice not to pull me over anymore. And they had a parade. They had the 4th of July parade in Harrisburg, and I was going to work through there. And it was all kinds of sheriffs riding behind me. Nobody bothered me. It was just that first time.
Wait, so what you say when they pull you over?
He pulled me over. Wait, what was your question?
Like, what do you be saying when they pull you over or if you get pulled over?
Oh, well, that whole thing is, a lot of people call it they call it right to travel, and a lot of people cite the right to travel that's protected under the 14th Amendment, but that particular right is not protected under that right to travel. The issue is not what your right is. It's that the government has the right to regulate interstate commerce, and they assume that you're engaged in commerce. Mm-hmm. So I sent a notice to either the Department of Transportation or DMV, whatever in Raleigh, and stated in there that I was not going to use my car for commercial purposes. And I said in there, and I'm doing this because I'm having issues with this child support agency. I told them on there. So they forwarded it to the Attorney General's office, to, what's his name?
Josh Stone.
And so I got a response from the Department of Justice, the State Department of Justice, and they say it was something like, this isn't a contract and whatever. They basically just reminded me of the state law that said, we're reminding you that to drive in the state of North Carolina, you have to have license, insurance, and registration, which what they said didn't matter. As long as I got a response, that let me know that they got my letter. So since it came from the state, that means the state got notice. And the sheriff's office in this state was created by the state constitution. So the sheriff is the state employee. And it's notice the agent, it's notice the principal. Notice the principal, it's notice the agent. So they were noticed. Even though that deputy that pulled me over might not have known, the state knew. So when he pulled me over, I stopped explaining it to the police when they pulled me over. But this was a sheriff. This is the first time a sheriff or a deputy pulled me over. And his response was totally different from how the police would do it. He wasn't, trying to tell me what the law is. He wasn't, being smart. All he said was, and he was cool about it, because I think he knew. He was like, well, you may have your belief. He called it a belief. And I've noticed, and when I see videos about that, the sheriffs and the, provost marshal, if you ever see the one with, what's his name? Something Unchained. I forget his name, but he had this half-hour video. But those sheriffs, these people know about it, and they call it a belief. So he gave me a ticket anyway. But when he came back, I had the light on in my car. I said, "Let me ask you something. Do you see any passengers in this car?" He says, "No." I said, "Do you have any evidence that I'm carrying freight?" He didn't answer that. He said, "I'm not sure why you would ask me that." And I said, "Well, I'm just creating a record. Your body camera is recording, right?" He said, "Yeah." And my phone was recording. So the whole point of me saying that was to rebut any kind of presumption that I was engaged in any form of commercial activity that would give him a reasonable suspicion that I was committing a crime by not having a plate on my car. That's why I asked him that. So when you try to defend yourself with that stuff in court, you can't use the Constitution, and you can't use the federal transportation code because it's a state court. You have to go by the state's rules. So you have to use case law that applies to either your district of appeals, which would be the Fourth Circuit, or the North Carolina court decision. And they do exist. I don't know for sure that they're listed in that memorandum of law in the Don Quixote abatement of common law. But I know either this channel you usually go by Alabama case law. So it's probably something from, I know, it was, it's a channel called Power Inherent in the People. He has a video of it. Power Inherent in the People.
Oh, okay.
But he used that same abatement in common law, and he actually sued for being pulled over, and I think they settled with him, or he won one of the two. But it's either there or the Here's the Deal channel. He has a so-called right to travel playlist, and he goes over a lot of case law that I haven't seen anywhere else. I think I know where it was. That page I mentioned that he reads from American jurisprudence called The Tribe. He did a video recently on the right to travel, and I think that's where he gave some North Carolina case law. I know I've seen it somewhere, and I wrote it down. It's not in that memorandum of law. There's a lot of stuff in there where they cover the principles, but stuff that's specific to this state, I don't think it's in there. But if you're not planning to use that for your ticket and you don't really fully understand that, I wouldn't mess with it, because you got too many cops for you.
Yeah, it ain't no joke out there in Cabarrus, man. I'm telling you, man. When you get in there, you're gonna see what I'm saying. They don't especially if you talking the law too much, man. They're gonna throw you in jail. That's what they do.
Yeah,
that's what they do.
I think you have to submit motions and make the prosecutor the one that just drop it. But if you go in court in front of those people, in front of regular people, regular so-called citizens who don't know about that stuff, they try to shut you up before you say too much in front of them, because they don't want everybody else to what do they call it? Public alarm. They don't want that to happen.
But then they call you up in front of everybody and like they try to start with you, and then that's what I'm saying. You start saying stuff, and then that's when they're getting mad. Now they're like, "Oh, he's
I don't think those judges. The judges, from what I understand, they get chosen randomly to hear cases, so they don't necessarily have the opportunity to read the case. They might start, in your case, but early on, they don't really know what all you filed until you present it to them in court. And I think that's what happened with me. It was a judge that he said that I was trying to get out of paying child support, and when he said it, I just had a flashback of all the nonsense that I've been through in the last few years, and I shouldn't have said it, but I couldn't help. I asked him. I said, can you clarify what you mean when you say trying to get out of? And somebody in the back went, ooh. And I know it was the child support attorney was sitting in the back. It might have been her. But he sat back in his seat, and his seat had wheels on it, so he's rolling to the side. And I wouldn't take my eyes off of him. I think the Scorpio came out what happened, and I think me saying that is what made them continue this case for so long. But I didn't cuss at him or anything. It just rubbed me the wrong way that he said it, and he sat back in the seat. He rolled back, and then he rolled to the left as he was talking. He was stuttering. He's like, and he tried to talk his way out of it, but I knew exactly what he meant, and it was the way he said it more than what he said. But when he was done, I was like, "Oh, so you didn't mean that in a negative way?" He's like, "Oh, no." I was like, "Okay, I was just checking." But other than that, I try not to be. That was the second time I filed that motion. I filed a Rule 60 motion to have the order vacated. But the first time the first hearing I had a different judge, and he read this 7-page letter that I submitted. That now that I look back, it was a lot of stuff that I didn't fully understand about the real law at the time that I was talking about. So it looked like some sovereign citizen stuff. And he said, before we had the hearing, I asked him, they were swearing me in. And I asked him, I was like, do I have to raise my hand? Because I wanted to know why the right hand is specifically the hand you have to raise when you're being sworn in. That's all I wanted to know. I wasn't trying to prevent, jurisdiction or anything like that. And I think that might have been what he thought I was doing. He goes, just raise your hand. And I was like, I'm just asking a question. Like, why do you have to raise it? And before I could finish the question, he puts his mouth up close to the mic and goes, raise your hand. So I just raised my hand. But remember when you were going over, I guess you were reading American jurisprudence or juris secundum, one of those, and it gave that Latin term for when you raise your hand and you swear to tell the truth.
Yeah, I know what you're
saying. And I had you go back, and I asked you to go back and read it again so I could look it up. That's what they do. That's what they use to presume that you are the person. You go in there trying to, say I'm not that name and all that, but you raise your hand and you swear to tell the truth. And that's what they, other than you received the summons, gave them a residence, all that stuff. But if you object to it, then they're gonna assume then they'll say that the defendant has failed to appear, and then they issue a bench warrant. So
No, I
I
discovered
don't try to
it's a
do
case.
that.
It's a case law. George Gordon, just old dude George Gordon. He like do case video, law videos and stuff. But he won the case in the Supreme Court about that, about his religious belief.
Call, man. He done raised his hand now. I'm sorry, y'all. I'm sorry.
All right.
I hopefully I covered everything, but if I come across that allodial title, that stuff, or anything that I can add to this, I'll leave it in the comments.
All right. When you get some time, make sure you send me your email so I can send you that book. Not you, SG, the other guy. Send me your email.
Okay.
This child support book, and you need to follow this guy right here. You need to go and read all his stuff. This man know what he's doing. He knows exactly.
Okay, I'm definitely looking into it.
All right, let me go to the next caller, y'all. Sorry about that, y'all.
All right, man.
All right. How do I? Thank you. Mute it like you mute it. Right here. All right. Who is SG? All right, caller 8588.
Hey, been waiting for an hour and a half.
Is this Gary?
Must have been kicked off.
This Gary?
Yeah, this is Gary. Yeah, hey, about the courtroom procedures, raising a hand, you don't have to, because they're not courts. Yeah. What you do is you write a testament. They're a testament, okay? That's all you have to do, is write what they call is a declaration of decree, okay?
You should be able to just...
You write a declaration of decree. Yeah, a testament, affirm, right?
You should be able to just affirm, like, especially if you start citing Bible verses in there. When it, like Yusuf says, you don't say anything, you let your yes be your yes and your nay be your nay, whatever, something like that. They can't force you under oath. You know what I'm saying? Because they not...
Right, because they're not courts because they're selected. They're selected by a group of people who hire them. That group of people is the Department of Health and Human Service, Child Support, and Social Security.
Yeah,
and how you find this out, and I keep telling people how you find it out, is by it's called Congressional Resource Services that do, and you hear this, they say the intent. You have to cite the intent. The courts say the intent of something, okay? You have to cite the intent. All right? I don't know why we're breaking up so bad. So you go on the Congressional Resource Services, which is the legislation. They write the language for the legislation. Now, people keep saying they have a contract. They have a contract. Okay, you have a contract. You have a contract. You have a contract. You are, if you have a Social Security, you are an employee of the government, because back in 1988, Bill Clinton signed denoting everybody as a employee of the government if you have a Social Security. So people stop thinking sovereign citizenship. You can fight it by stating on an affidavit, you do not work for the federal government. You have no intention to work for the government.
They call it a
do not
or something like that, if I'm not mistaken. The U.S. citizen is a friend.
Yeah.
So to speak. Go ahead.
And a Michigan Supreme Court judge had stated, because everybody is using pronouns, okay, you do not have to recognize that, okay? But you don't have to they don't have to recognize it, but they have to address what they are going by. So you can't disrespect them, what they're saying, okay? So when child support comes in and says you're the non-custodial parent, what is the first thing you're supposed to say? I object. That is a program. Child support is a program.
Yeah,
if you take the family court section,
it's literally a program.
If you take the family court section and child support section and the federal court section, it's all the same. So how is it not a program? They want you to think it's not a program when they're citing their statutes. I challenge jurisdiction, and I asked them, how is the jurisdiction applied to them? And you know what they said? 598-1. That is a child support program. 598-1. That's a child support program.
Yeah, I bet you it's some sort of statute or some sort of code within an administrative agency or something like that.
Yeah. And another thing, you heard of the Personal Responsibility Work Obligation Act, right?
No, this is my first time hearing about that.
Oh, it's in child support. It says the Personal Responsibility Work Obligation Act is when you sign up. You heard, when you sign up into the program, you fulfilled your obligation. Okay? So how do you sign up? By walking down to the unemployment, signing up to the unemployment, or your Iowa, where I live in Iowa, so it would be the Iowa workforce. When you sign up, you just signed up into the program. It doesn't take, child support don't have to do.
That must be some sort of local
What's
legislation.
that? Yeah, it's legislation. See, it's all partnerships, okay? Partnerships, okay?
Is that federal legislation or state legislation?
State legislation. But it comes through the Unemployment Act.
Okay.
How do you get your money? How do you get your money? Through unemployment. Okay? So when you sign up to unemployment, you're agreeing that child support's going to take your money because the federal government is giving you welfare. It's welfare. The state pay, you pay.
I'm a little confused. You lost me a little bit, so I'm just a little confused. Sorry about that.
Okay, when you sign up for unemployment to get weekly money, okay, it's paid by the government. Okay, it's paid by the government.
Okay.
The state puts in some money. You put in some money. Okay, for unemployment. It goes to the government. The government says you are a dependent now. And a dependent is what? Somebody in need. Temporary aid for needy family. Social Security, dependent. Social Security, dependent. IRS, dependent. That's all terms that the government uses to say that you are a dependent person. You need their help. You follow me?
Yeah, I got you. I'm following you.
So when they use the word dependent on anything, you are saying you are in need. So child support comes behind on the parent locating act, okay? The parent locating system, okay? All these agencies have to reply to the state. They file to the state. They give the Social Security number to the state. They run your Social Security. They fine you. Blah, blah, blah. There it goes. Now, the postal manual, if you look up the postal manual and child support don't need to give you a certification, a certified letter saying that you are in child support because they consider you as an employee. And they're doing internal service. So you don't give them any letters saying, well, you have to update. No, the fuck you didn't. 1974 says, Privacy Act says you have the right to live in private. You don't have to give no information out whatsoever. They try to use that sovereign citizen shit on me, and I shut them right down. Well, you're calling me a sovereign citizen. You're calling me a sovereign citizen. Is that a statute? or is that just an opinion? But I do know one thing. Qualified immunity is a statute. So you're a sovereign citizen because you believe the Constitution don't apply to you.
Well, no, they actually, unless they incorporated it through some sort of statute, qualified immunity is derived from case law, or so to speak, which is common law. Even
Right.
though there's
Right. When you work in when they work in partnership with the government, they feel they get qualified immunity, or they wouldn't be able to get anybody to work for them.
Yeah, I'm of the opinion that they
I'm
don't
not
have
going to work for you.
That's my opinion. I'm of the opinion that police officers,
Well, here's
statutory officers anyway, I don't believe that they should be entitled to any form of immunity under the common law because they're not acting under common law jurisdiction.
Here's what I did. I went to the federal government, the FBI in Cedar Rapids, Iowa, where I live, okay, and filed a human trafficking against the judges and child support. I sat there for 1 hour and explained to them, broke it down, how they are using it as human trafficking. They say a birth certificate is an obligation. I said, no, don't. States right here in the Inspector General fraudulent birth certificate that a birth certificate is only to notify the U.S. government that a baby was born in the country. Doesn't say anything. But then he says, furthermore, other agencies use it for other things, like food stamps and getting assistance. That's it. No other thing. They have to list everything. Okay? If they say they're going to use it as an obligation to pay child support, it's supposed to list it. That falls under the Plain Language Act. So I went there and told them this is it. Okay? How it's human trafficking is they use the word coercion. If you don't pay your child support, we're going to arrest you. Take your license away. Take your recreational license away. Take your fishing license away. Take your right to own a bank account because they're going to garnish it. But under the Title 15, under the UCC law, 15-17 section, I told you before, under 1681B, the United States government is supposed to do a credit check on you to see if you have the ability to pay and inability to pay. But then underneath they say they can't use that in court. But it doesn't say you can't. It says they can't use it in court. Objection. Child support representative. Do you have a piece of paper stating that the U.S. government did a credit check under UCC
90 seconds.
1681B? It specifically says the United States government is supposed to do a credit check to see if he has the ability to pay or inability to pay. Do you have that? Your Honor, we're only here for name, the amount, and the order. That's it. That's what they're only allowed to
60
say.
seconds.
They can't bring anything else up because they tell them.
See, it sounds like what you're saying. The correct administrative procedure before they adjudicate you for child support is to determine if you can or cannot pay child support. Is that it?
That is it. But they say what you just had said, a judgment is binding. So you know what the judge said to me? Because we put it in the divorce decree, it's binding. But you never agreed to it. And even I told you about 3-4 months ago when I first came on to read essential
10 seconds.
for judges and lawyers for child custody and child support. It's a 400-page document that runs through everything. And on one of them, I'm still trying to find it. I got kicked. I have to find it tomorrow. I want like page 142. It says child support was made for the fathers. Okay, but then when the mothers, the Act of in 1975, when or that mothers, those 5 mothers brought the child support agency to court in Arizona, and they said child support was not made for the children; it was made for the state.
Yeah.
Okay. So the state interest is for recoupment. They said that from the beginning. The federal and state participate into this program for appropriation funding. Okay, so the state is acting, like we all know, as the agency of the federal government for recoupment. So they don't have qualified immunity because they're acting on the behalf of federal government to restrict your movements, restrict your liberty, restrict your happiness. Coercion, restriction of liberty. And they say if you don't pay, you're going to jail. So I said, this is all human trafficking in the 4 elements of to benefit, okay, transportation, over state lines for sex. Okay, well, we all know we get bent over and get fucked. Excuse my language. So, you know, you could throw that in as having sex because you might wind up in prison and be sodomized. Who knows? But no, all fun and games. I won't hear anything until next month or 2 months from now because I am going to court back because they told me that when I wrote that my wife could not leave the United States because Hawaii is not part of the United States. Mm-hmm. So they got slicked in 2000 and said 2020, they got slicked and wrote up a new thing saying that Mr. Williamowski can't take the children out from Hawaii just because the mother don't want me to take the children out of Hawaii. Oh, wait a minute. Didn't you just say that Hawaii is part of the United States? So I could travel with the children, correct?
Yeah.
So why am I being restricted? Why am I being restricted if there's no injury? Because the mother doesn't want to pay for her side of the transportation. On even years, she has to pay, and on the odd years, I have to pay. She pays one way, I pay the other way. But now she don't want to do that. So isn't that a form of restricting me access of my children? Yes, because I only make $2,403 a month on Social Security, my benefits. Okay, because I'm 63, I retired because of my health. Right. Mm-hmm. Then they say Mr. Williamowski can't read a statute. Wait a minute, I can't read a statute? I brought up 710.6 states that anyone, okay, conceals the movement of a child is considered doing a great misdemeanor, okay? Blah, blah, blah. It also says on the bottom, any parent, okay? But what they're trying to do is use it for just the mother, saying if you don't bring back the children, we're going to cite you for kidnapping. Well, the mother already kidnapped the kids out of the state when she didn't file for permission to do so. Now, her husband is saying because he was in the military, he was able to conceal the movement on a child because he claims he worked for the government in a top secret division that allowed him to do that. I said, the fuck he did. Because he can't do that. That's the mother. The mother is the custodial parent. And besides that, I'm ex-military. I know the law. He has to get it from the admiral in Hawaii because he is the one who has control of all the armed forces over there. He has to be approved. Just because the mother said it doesn't mean it's true. No evidence. She got away with it. Okay? It's like what you said. It's presumption. Everything in family court is a presumption that you did something wrong.
Almost everything. It's not just
these new things.
It's pretty much everywhere.
Yeah. This thing that they do for order of protections or PTO, whatever, temporary order of protections, when there's no police involved, no prosecutor, is unconstitutional. Why? Because they're taking your Second Amendment right away. A right to own guns. Because even if the prosecutor did not get, they can't, if you don't have any evidence, doctor, witness, okay, doctor, witness, police, and documentation, those are the four elements, you don't have a case. But because of the VAWA Act, Woman Against Violence Act, they have to find you guilty because they have a interest of it. Why? And I'll tell you. Thanks for asking, Mr. William Hoskin. They can write the order, so you have to pay for everything. Outside visitation with a supervised visitation. Outside therapy for the mother. Everything they can say you did an injury to the mother and you didn't do anything. But the judge presiding on a no jury trial has the right on a presumption that you did it. It's a possibility that you did it.
Yeah, well, you got to rebut that presumption, though. She can't just say, she can't.
Yeah, I did.
Nobody can make allegations against you in a conclusory manner. Unless you just.
And here's what they got away with it.
Huh?
And here's how they get away from doing it. The courts have discretion.
Yeah, but they can abuse that discretion.
Wait a minute.
You can't.
That's right.
Exercise. That's not a proper exercise of discretion. How are you going to properly exercise?
That's
discretion?
not a.
Huh?
Not a judicial discretion. It's called abuse. You said it's abuse. It's actually advocating.
That's why they call it abuse of discretion. They don't have discretion because you don't see
right.
Like true Article 3 judges or whatever you want to call it. That standard is not applicable to them. The only one who can determine if they abuse their discretion would be the people. You know what I'm saying? Because the people are
right.
The people determine. They say what the law. In my opinion, I'm just telling you. In my opinion, because the if we're going to talk from a constitutional point of view, when the Constitution was created, essentially what the people did was they created 3 administrative agencies. But these administrative agencies are of the people. They belong to the people.
Mm-hmm.
The judiciary is an administrative agency of the people. The legislature is an administrative agency of the people. And the executive is an administrative agency of the people. And the law that they are administering is the Constitution. That's what they're doing. But they can't exercise. Let me rephrase that. It's also inequitable. But anyway, that's not a proper exercise of so-called judicial discretion. I'm gonna call it quasi-judicial or whatever. But that's not a proper exercise of discretion in regards to ruling on evidence that you don't have that has been admitted into evidence. In other words, you can't rule that somebody is guilty of allegations without evidence substantiating, or in other words, proving that the allegations are true. That's really what I'm getting at. But they will do that though. But you're not
Right.
lying. They will do that.
Oh yeah, they will.
When they do that though, you make your objection. So if they overrule your objection, you trying to make a record anyway, and you take it up on appeal, and you just re-argue it
Right.
all over again, and you say he abused his discretion.
When they arrested me, because this is everything I say happened to me, okay? And this is what I rebut when it happens to me.
Okay.
The passports. State does not have an interest in children's passports. People got to understand that. When I went to court and they said, you have to sign the passports, did you ask them, what authority do you have? Oh, because we put it in. No. You do not do that. It's outside the United Family Court. You don't have authority outside of family court. Remember you just said that if you get a contract and you sign with child support, okay, you said that they'll hold you to it. If you are paying $50 a month, okay, they'll hold you to it. But here's the thing that people don't understand. If you read the child support, it says a judge has discretion to raise it because it's in the best interest of the children. No, it's not. We just know in Blessing v. Freestone, child support was not made for the benefit of the children. It was made for the treasury. So you're just actually breaking it so the benefit be for the state to get more money because it's recoupment. So anybody who says they have a contract and the state can't break it is not understanding the child support law because, well, I'm not going to say law, I'm just going to say regulations, statutes, because they say a judge can break anything for the discretion of the child. And that's where you have to break. You have to say, whoa, wait a minute. Blessing v. Freestone.
They're operating off the presumption that these kids, when you're in a territorial court and you're receiving benefits and so on and so forth like that, they're saying you are dependent. They're saying you're incompetent. You can't take care of yourself. So what the state is doing is they're acting as if they are the parent. That's what they're doing, and that's
right.
That's their standard. That's the public standard in regards
right.
to kids. The private standard is
right.
Is a compelling public interest because they are infringing on a fundamental private right when it comes to you and your kids and you exercising.
If it's a collection agency and the Congressional Resource Services say it is a collection agency in like a roundabout way, okay, how can not any collection agency come and say, hey, look, you owe child support, we're going to collect on the mother's house? They can't. Only if the federal government says they can't. Yeah, I don't know any collection agency that collects on child support because Georgia already had a scheme on that, and the judge shut them down. The federal judge shut them down and said, no, you can't do that. It has to go straight to the, you know how you pay the child support? Yeah, you pay the child support because that's the government, okay? That is the government. They're outside. Go down to any Health and Human Service building, okay? You won't find child support in it because it has to be separate from what you said, the corporate side. What's that word? Begins with a C.
So you said it has to
from the state, yeah.
They have to make it look as if it's an independent agency, so to speak.
Yeah, single separate unit. You don't find Department of Health and Human Service child support in there.
These people funny, man. These people so
They,
funny.
the child support is nothing but a program. That's all it is. And they're
To me,
acting
it seems
this.
like the federal government incentivizes the state through administrative agencies to go after quote unquote absent parents to how do I put this, to keep these kids from being cast up on the public, or so to speak. But the problem is, like the
Yeah,
author
you're right.
put it, how
Yeah, you're right. That's what they're doing.
okay.
They're
The problem
converting.
is though
They're
they're
converting.
enforcing this stuff, what they call it, ultra varies. In other words, they are enforcing this program, or so to speak, um, beyond the scope in which it was intended to be applicable. Because you haven't even you just presume that I'm an absent parent. You haven't even we haven't even had a hearing on this. You're just going off the presumption.
That's right.
So you have to. So in other words, if y'all are listening to this, you have to rebut that presumption of being an absent parent. Not only that, let me show y'all something else. I'm gonna get off here in like 10 minutes, y'all, but I can't be on here all night. But let me show y'all something. All right, the guy right here. This is the guy right here who wrote the book. All right, when he said this case citation, right, I just showed that this stuff goes back at least probably about 100 more years. All right. Anyway, it says whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. So let me show y'all. That's equity, by the way, y'all. That's equity. It doesn't say it, but I'm telling you it's equity. All right, so let me go back. Where is it? Right here. Not too long ago, I had this on the screen. I was hoping y'all would be reading it. But this is the principle in equity that is being enforced right here. What I just said, whatever deprives the parent of the father, whatever, without fault on his. This is the principle right here. So let's say the mother of the kid, and ladies, don't take any offense to this, but I'm speaking from a man's point of view because I'm also a father, and this has happened to me before. But let's say the mother of the kid is denying you, um, what do they call it, a FIFA relationship or something like that. In other words, she's preventing you from being a father, or so to speak. And at the same time, she runs her little narrow, stubborn ass right on down to these administrative agencies and try to put you on child support, you know, because she's saying you're not taking care of your kid or whatever. But she can't do that. That's inequitable because no one can take advantage of his own wrong. You cannot be the cause of which you can of something that you're complaining of. You can't do that. So let me
Right.
read this
She
principle.
goes into court and says, "I want." Hold on. She goes into court and says, "I want custody of the children." She goes into court and says, "I want custody of the children." But you never ask the, they never ask her, "Do you have a place to live? Do you have means to support the children?" They don't ask her that. She doesn't do nothing, and they give her the kids.
Well, you have to the
But
reason that they doing
you,
that, in my opinion, is because they have a pecuniary interest in this. They have a financial interest in this.
right,
So
right.
they gonna
Hey,
always do that, but
be,
it's your responsibility to get the facts, all of the facts on the record. That way, if the once you have all of the facts on the record and the judge issues an adverse ruling against you, contrary to those facts, you can appeal it for an abuse of discretion. Because he can't make reasonable conclusions on law that are in regards to facts that are contrary to his ruling, is what I'm trying to say, if that makes sense. He can't do that. That's an abuse of discretion. That's a violation of due process. Not only that, you allowed her to take advantage of her own wrong. You can't do that.
right.
This does not just
Let me
apply.
read this one thing to you.
Go ahead.
Let me read this to you. It's very important. This is about the passport. This is my next one. Okay.
Okay.
Fathers, you have to put this in your divorce decree. You have to put this in your divorce decree. It's called a EXEAT bond. Okay. Can a minor travel internationally with one parent? If the child is traveling with only one of their custodial parents, they must have a letter of consent, preferably in English, and notarized from the other parent or signed by both. Okay, that's the first one. It's called capital EXEAT bond. I asked the judge, I told the judge, this is what I wanted. They said, they never heard of it. I said, yes, you did, because you put it in child support as a purge, as a Hague Convention Act. If a parent goes overseas who owes child support, you do this as a warrant to bring him back. It says, as you go through divorce, you might get worried that the ex-spouse will ignore his or her legal obligation. Worse is that your ex-spouse is traveling to a foreign country with your kids in tow. If that happens, the court will find it impossible to impose the tenets of the child custody agreement outside U.S. jurisdiction. If the thought of your child, a child traveling abroad with your former spouse, wakes you up at night, it is critical to take precaution measures and understand the state law regarding children traveling overseas. You find that in the passport section. That's what I found. Okay?
Okay.
It is a security bond. They do that to fathers. Well, you want to go overseas, you're going to have to pay us a purge bond. Okay? A security bond that provides a guarantee that the other parent will conform to the terms of the divorce settlement and child custody agreement while traveling with your kid to a foreign country. It is $50,000. She has to provide 5% of that. The judge said, they didn't hear, they don't know anything about it. I said, yeah, let me flip it to the family book section. And I showed them. Okay? They don't like me because I do my research.
Yeah, you better.
They accuse me of saying I'm a sovereign citizen. No, I never said that. I said the law don't apply to me if there's no injury. They have to have an injury. Because you want my financial statements, I'm not giving it to you. Absent a warrant. And state why. There's no law that says you have to give them DNA. Period. Unless you committed a crime.
Right quick, Gary. I'm gonna get off in like 5 minutes, man.
All right.
I'm already going over my time.
Okay.
I got a question right here. Freedom asks me. Let me see. He says my voice is low. Is my voice low? Can y'all hear me? Is my voice low, y'all? Unless it might just be his computer. I don't really know. We Are DNA says, do the courts care about this being brought up in court? In regards to I'm guessing you're asking about this right here. No one can take advantage of his own wrong. Is that what you're asking about? We Are DNA? If that's what you're asking about, yes, they have to recognize that. They want to act like they courts. Do y'all really think that they're going to tell you that they're not courts and they don't have judicial? They are not finna tell y'all that. They not going to tell you that. So they gonna have to do what they're supposed to do. And you bring this stuff up. They acting like courts. They acting like courts of equity and courts of law.
Right.
So you
have and that's one thing.
Up.
That's how I challenge jurisdiction on them and say, hey, are you judicial court or administrative court? They wouldn't answer it. Even if you put on there failure to answer would fall into a default on your part, they don't give a rat's ass about that. They don't care
Yeah, I ain't man.
because they
I don't
don't
care
have
what
to here.
I don't care what they do. I'm gonna make my record, all right? Because they're gonna run over you. They're gonna
Oh yeah,
ignore
you
you. They're
make your
gonna do
record.
all of that. What you have to do is you have to just make your record and just go ahead and appeal it. Just go ahead and
I
appeal it.
think, I think, I think the best thing to do is go to the federal government, write your human trafficking thing, plus the Department of Justice, write them a letter stating how it's human trafficking because they're using the children to benefit on 66%.
All right, hold on.
Hello?
Let me get back to this right quick. Let me see. I can hear it. All right, I think We Are DNA is talking about this. So let me read this, and then I'm gonna read y'all one little argument that I made for somebody in state court that is focused on this principle right here that I'm about to read y'all. This is why you need to study equity. All right, this does not just apply in child support cases. Equity is applicable everywhere. Nobody can take advantage of his own wrong. All right, so let me read this right quick. No one can take advantage of his own wrong. In vain should he seek the aid of equity who has violated equity. Such a person, in sight of a court of chancery, has unclean hands. You violated a principle of equity. So obviously, if you do that, you're not going to get equity. If a person could take advantage of his own wrong, it would be a direct bribe to commit the wrong. This maxim applies where a trustee buys property in his own name with trust funds, where a trustee makes a profit by means of his trust, where any fiduciary obtains a good bargain by means of his position of confidence or influence, where a tenant or trespasser cuts down timber, where a party stands by and does not object to his own goods being sold as another, where the true owner allows a bona fide purchaser to make improvements. What they're doing is they're giving you examples of where this principle is applicable. Where the true owner allows a bona fide purchaser to make improvements, and where a defendant fraudulently conceals the cause of action from the complaint, and then pleads the statute of limitations, where a party, by his own words or conduct, willfully causes another to believe in the existence of a certain state of facts and induces him to act on that belief. The former is concluded by his words or conduct, as also is one who negligently allows another to contract on the faith and understanding of a fact which he can contradict. In brief, this maxim operates to stop all persons whose words, acts, or silence have misled another to his injury. So let me read y'all something right quick. This is an argument that I made for somebody. I think it was in a state court. It's not on the computer. I have the paper in my hand. I don't know if you can hear it, but I'm tapping the paper in my hand. But this is the argument. I said first, appealee cannot cause the alleged dependency that she complains of, meaning appealee cannot unreasonably refuse to allow. I'm gonna call him. I'm gonna use the name John Doe because this is a dependency case in which a dad was unreasonably um deprived from basically being a father of his kid by the kid's grandmother or whatever. Back to it.
Oh, they have a case on that in Iowa.
Huh?
They have a case on that in Iowa. They have a case in that about Iowa. The guardian litem, okay, was stopping the mother from seeing the children, and the state said she can't do that. The guardian litem can't, or the custodial guardian cannot stop the parent from seeing the child.
It depends on the. Well, I would disagree with that. It depends on certain types of facts of the case. But let me read this right quick, and then I'm gonna get on off here, y'all. Let me start it over. First, appealee cannot cause the alleged dependency that she complains of, meaning appealee cannot unreasonably refuse to allow IL to continue receiving necessaries and a meaningful parent-child relationship from her natural father, appellant, and have standing to prosecute a dependency action on the ground of appellant not being IL's legal father, or by fraudulently in her initial petition alleging the appellant as unknown. So what happened in this case was the appealee, which would be the grandmother, lied and told the court that she did not know who the father was. And she's been knowing the father for years, but she lied about it. And the father filed all these affidavits in court, and she never denied any of the affidavits. She didn't dispute any of the facts, none of it, or whatever. So this is the argument that I made for him. He took it up on appeal. Right now, we just waiting on a ruling now, right now for it. But that violates equity. You can't do that. You can't. How are you going to complain about something that you caused? Does that make sense for you?
Well, they do. Mothers do.
Yeah, I know they do. I know
Mothers do.
I know. But I'm telling you,
Happened to me. Happened to me in family court with the passports. They took my rights away. They took my rights away because I didn't refuse. I refused to sign passports.
Now that I understand equity, it's not going to never happen to me again. But this is what y'all need to do. You need to invoke that principle, right? But you have to know how to articulate your argument based on the facts of the case.
Right.
The facts of your case show that somebody is committing fraud, or they're fraudulently. Let's say that they are fraudulently invoking a legislative court's subject matter jurisdiction by lying or by misrepresenting facts that are material to the court exercising jurisdiction. That's fraud. You can't do that. No one can take advantage of his own wrong. You can't do that. You can't say that my father is a deadbeat. He don't do nothing for his kids. At the same time, deny him access to being a father without grounds, without some justifiable reason for that. What reason are you doing that? What fault? Where's his fault for you doing that? When he's talking about right here, without fault on his part, because you can be responsible for something. Like, let's say if you might be an abusive man, or your drinking might be bad, or I don't know what it is. You know what I'm saying? But something can
all has to be documented.
Huh?
All has to be documented.
Yeah, or you better dispute it. You know what I'm saying? The burden is it's
yeah,
not even
you
on you
better
to,
dispute it.
it's
right.
not even on you to disprove any of that. It's on her to prove it. You don't have to prove nothing. You don't have to disprove nothing. She has to, because the burden of proof is not on you. It's on them. It's on he who asserts he was bringing the claim. So it's, if she's bringing a claim, she has to prove it. But they gonna say
now my next court.
Go ahead.
My next court case is about her having my rights taken away because she has sole custody because I wouldn't sign the passports. But since she has the passports, she has never brought the children to see her grandmother in the Philippines. And that was the main purpose of having me to sign the passports. So by her doing it for the last 4 years, she just showed that she is in a repetition of not wanting to do it. So she's doing it. She's going to the Philippines 4 times, not bringing the kids. But this was the main purpose of having me to sign so she could bring the kids over. So that's wrongdoing. She went into court, used the court to advocate for her to get sole custody.
I'm of the opinion that I don't know, I would have to like read your case to see what exactly happened. You know what I'm saying? But it sounds like you can get that judgment vacated. To me, that's just what it sounds like. It would probably be a little difficult because the state has a financial interest in all this stuff. So I don't know, but
well, they don't have a financial interest now. They don't have a financial interest now because my disability they call that not child support. They call that outside child support.
Oh, so it doesn't qualify.
Because
I'm guessing it doesn't qualify as income, as taxable. I mean, as income to use to support the kid or something like that.
yeah, something like, they won't tell you how, because I've asked them that.
Oh,
They just say, "Oh, it's paid. It's only means. It's your only means of living on." Okay,
yeah,
and I trust me, I don't stand there and look stupid. I ask questions.
yeah, gotcha.
You better ask questions.
You better. You should.
Just because the judge says I have to sign the passport, you better have authority to tell me what statute says I have to sign.
Mm-hmm.
Where the United States government says two-party consent, that means that. So that means I have reasonable expectation of saying no to it.
Yeah, they can't force you into
And
nothing.
yet, the
They can't
state,
do that, man.
no.
That's a violation of they
But yet
violating
the
equity
state
when they do
says,
that.
I'm unreasonable without a fitness test. But they say they don't have to do that. Yes, you do. When you're taking a liberty test, the liberty constitute right away. Yes, you are. I mean, hey, I'm going to let you go because you said you got to go. When are you going to call me? We got a lot to discuss.
I think I have some time now. So
Because you said it was going to be after your court time.
Huh?
Yeah, you said after your court filing paperwork, you said you're going to call.
Yeah, we pretty much done for right now. I don't know how long, but we done for right now. We just waiting on rulings from the court now.
But
Huh?
I'm going to give you this document. It is what Gerald Ford said about child support being unconstitutional. And Congress got to fix it. And Congress never passed child support. Congress only passed the due process clause within that program. That's what they did. How many times have you heard that you have the right to notification, right to a hearing, or right to rebut? Those are the 4 constitutional rights they have to do. Other than that, they don't have to do nothing other than give you constitutional rights.
Well,
And those are the 3.
These remedies right here, stuff like this, when it says whatever deprives the parent of the right to the custody, blah, 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 you have to bring up this argument in there. You have to make this argument.
Right.
It doesn't seem to be incorporated in their statutes. So you have to bring it up. And you have to make the argument.
Right.
That's what you got to do. But look, I got to go, y'all.
Because they're not going to tell you.
Huh?
They're not going to tell you.
No, they're not.
Text me on the phone. Text me on the phone when you think you're going to have time, and then call me. Because we have a lot to discuss. I'm going to give you the document, okay? And you'll find out how they're doing it.
Okay.
Because child support was not made by Congress. It was made by the executive order. And that was for their employees to follow. That's what they say, for the employees to follow. That's it.
All right, y'all. Look, I got to go. If I didn't get
you
to
can find it yourself if you want.
Huh?
You can find it yourself and pull it out yourself, but I'm not, I'm willing to give everybody the document, okay? But I spent 6 years looking for it. I feel right now that you're the only one I should give it to because you understand.
I have to make time to read it, man.
This is
I gotta make time.
It's only a 95 page document.
That ain't that bad.
But you only have to read the first 40. You only have to read the 40 pages. That's it. And the rest is how they made it as a collection agency. And And that's because they said they want to make money off of the Social Security card.
All
Now,
right, look,
how
I'm
can,
yawning. I gotta go, man. I'm yawning right now. Let me get off here, man. Y'all, everybody enjoy your weekend. Good night. If I didn't get to your call, I'm sorry. Just if you got any questions, just shoot me an email or something, man. And I'll try to get to it whenever I can. Just shoot me an email. If I can't get to it, next time I go live, just ask your questions. I'm getting a headache right now. I gotta go.
yeah, Gerald Ford said it was unconstitutional. So if the president said it was unconstitutional, aren't we supposed to listen to him?
Oh, I don't know. Depends. Oh, depends. But anyway,
All right. Thanks, bro.
all right. Good night, y'all. Good night, everybody.